Again, we're just going to have to say, as a policy of the alliance,
Okay.
we don't comment on individual immigration status.
Okay.
എനിക്ക് പറയാനുള്ളത് ഇനിയും H-2B വിസയിലേക്ക് അപ്ലൈ ചെയ്യുമോ എന്ന് ചോദിച്ചു കഴിഞ്ഞാൽ ഇതേ രീതിയിലുള്ള ഒരു വിസയോ ഇതേ രീതിയിലുള്ള ഒരു ജീവിത സാഹചര്യത്തിന് വേണ്ടിയിട്ടാണ് വരുന്നതെങ്കിൽ ഞാൻ ഇവിടെ വരേണ്ട കാര്യമില്ല. അതുതന്നെയല്ല, ഇനിയും ഇതേ രീതിയിൽ ഇവിടെ വരാനായിട്ട് എനിക്ക് വിൽക്കാനായിട്ട് വീടോ കയ്യിൽ സാധനങ്ങളോ ഒന്നുമില്ല.
If you're asking me, will I apply again? If it is this same way that I'm coming, I have no more homes to sell or nothing else left in my life. I would not come here under this circumstance again.
If you could, and I don't care which the witnesses takes this question, but talk to me more about this recruitment process. Who the recruiter is? It sounds to me they're getting compensated basically from both sides. The potential employers are compensating the recruiter to find workers. You're having to pay to come to the United States. And I know there's been some changes there, but talk to me a little bit more about that. And I know we're going to explore this issue with the second panel, but was interested in your thoughts on the recruitment process. And I got the general gist, but if you can go into just a little bit more, I think that'd be helpful. And I don't care whichever one of our witnesses wants to go. But my time is running, so one of you jump in there. Mr. Raju, go ahead, if you'd like to. Or Mr. It doesn't matter.
Bueno, nosotros como experiencia que tenemos, la experiencia personal y experiencia de las personas que vemos a diario,
Our personal experience and also the experience that we see daily as organizers,
hemos visto que esto del reclutamiento es un negocio total.
we've seen that the recruitment process is totally a business
and this
or a
is this is a
scam.
guy who's not just somewhat naive in all this. Is the recruiter a organization in your home country, the country you came from, your native country, or is it recruiter a company here in the United States? How's it typically done?
Esto es una cadena que comienza desde los Estados Unidos y va a nuestros países.
It's really a chain that starts in the United States and then comes to our countries.
Hay reclutadores locales en Estados Unidos y hay los reclutadores en nuestros países de origen.
There's local recruiters in our home countries,
Donde todos ellos ganan dinero de nosotros
and everybody is taking money from us,
y nosotros no recuperamos absolutamente nada.
and we're unable to recuperate
Repito,
anything.
es un negocio.
I repeat, it's a business. this
I understand
recruitment.
that. Okay, Mr. Chairman,
I
thank you.
thank the gentleman for his question, and actually, I mean, that's something that this subcommittee is worthy
Yes.
of a little bit closer look, because you raise an interesting point. Are people making money from both sides here?
Definitely are.
And that's, thank you, Mr. Jordan. Chair recognizes Mr. Foster.
Let's say, I guess this would be for Mr. Raju. Did you have difficulty contacting the Department of Labor? Is there an 800 number? Do most members, most of the people in your situation have a cell phone? Or is there an impediment to even making contact with anyone who will help you?
ഈ രാജ്യത്ത് വന്നതിന് ശേഷം ഞങ്ങൾക്ക് ഇവിടുത്തെ നിയമങ്ങളോ കാര്യങ്ങളോ ഒന്നും അറിയില്ലായിരുന്നു.
Since coming to this country, we had no idea of the laws or the ways of this land.
ഇവിടെ വന്നപ്പോൾ തന്നെ ഞങ്ങൾ വളരെയേറെ ലിവിങ് കണ്ടീഷൻസ് വളരെ മോശമായിരുന്നു. ഞങ്ങളത് ഇമ്പ്രൂവ് ചെയ്യാൻ പറഞ്ഞ് ഈ രാജ്യത്തിൻ്റെ നിയമപ്രകാരമുള്ള ലിവിങ് കണ്ടീഷനാണിതെന്ന് പറഞ്ഞ്.
When we came here, the living conditions were horrible, and we asked for it to be improved, and they said, this is the living condition of this land. It's according to the laws of this land that you're living this way.
ഞങ്ങൾക്കറിയില്ല ഇവിടെ ഏതെല്ലാം ഡിപ്പാർട്ട്മെൻറ്റാണ് ഞങ്ങളെ പ്രൊട്ടക്റ്റ് ചെയ്യാനായിട്ട് ഇവിടെ ഉള്ളതെന്നുള്ള കാര്യങ്ങൾ ഞങ്ങൾക്കറിയില്ലായിരുന്നു.
We did not even know which departments exist to protect us.
ഞങ്ങൾക്ക് അതിൻ്റെ നമ്പറോ കാര്യങ്ങളോ ഒന്നും അറിയില്ലായിരുന്നു. അതുകൊണ്ട് ഞങ്ങൾക്ക് കോൺടാക്ട് ചെയ്യാൻ സാധിച്ചില്ല.
And we didn't have the number or information, so we were unable to contact them.
Did you receive any information at all about what your rights are as a worker?
ഇല്ല, പ്രത്യേകിച്ച് ഞങ്ങളുടെ കയ്യിൽ അങ്ങനെ ഒന്നും തന്നില്ല. കമ്പനിക്കകത്ത് ഉള്ള നോർമൽ എല്ലാ കമ്പനികളിലും ചെല്ലുന്ന ഹരാസ്മെൻ്റ് ഉണ്ടെങ്കിൽ കോൺടാക്റ്റ് ചെയ്യണം, അങ്ങനെ എന്തെങ്കിലുമൊക്കെ കണ്ടിട്ടുള്ളൂ. അല്ലാതെ ഞങ്ങൾക്ക് പ്രത്യേകിച്ച് ഒരു ഗസ്റ്റ് വർക്കർ എന്ന നിലയിൽ ഞങ്ങൾക്കുള്ള ഈ രാജ്യത്തുള്ള അവകാശങ്ങളെ പറ്റിയിട്ടുള്ള ഒരു പേപ്പറുകളോ കാര്യങ്ങളോ ഞങ്ങൾ കണ്ടിട്ടില്ല, വായിച്ചിട്ടില്ല.
No, we never got any papers or anything that said it. Sometimes in companies they say if you're harassed, you can call this number, but we never got any information like that, even hanging up in the companies.
One last question. Mr. Raju, can you weld aluminum?
Aluminum welding, but do.
Aluminum,
Yeah.
carbon steel, stainless steel.
All right, you have my respect. Particularly aluminum. One of the most humiliating experiences of my life was trying to weld aluminum. Okay, let's see. Mr.
And if the gentleman would yield, I mean, I know you're speaking not only as a amateur aluminum welder, but also as a physicist. Yield back.
Mr. Lopez, are you aware of any labor brokers that actually do a good job and treat their workers fairly?
Hasta ahorita yo solo conozco lo que es a mi patrón, lo que hizo conmigo, y no conozco a nadie más que haya tratado a un trabajador honestamente, que solo conozco a mi patrón por cara, pero por nombre también lo conozco.
I only know my own boss, and I know how he's treated me and what he's done to us. I actually only know him by name, not by face. I don't know any other bosses that have treated workers well.
Okay, and Mr. Castellanos-Gutierrez, how are these debts enforced? Are they enforced against your families back home? Are they enforced in the United States? Do you have to put all the money up front so that you become indebted to third parties? Or how exactly does the debt enforcement work?
Bueno, lo de la deuda, que es lo que nos pasa a todos los trabajadores huéspedes, desgraciadamente uno lo tiene que pagar todo al principio.
In terms of the debt that happens to workers, you have to pay everything up front.
Como le dije, en muchos países pobres como el de nosotros, no contamos con ese dinero.
Many in our poor countries, we don't have this kind of money.
Tenemos que vender muchas de nuestras pertenencias,
So we sell our things,
pedir préstamos a los bancos,
we borrow money from banks,
o en lo peor de los casos, pedirle dinero a prestamistas que te cobran una tasa de intereses demasiado altas.
or in the more common and worst case is when you get loans from loan sharks that charge huge interest rates.
Y todo porque los reclutadores nos pintan muy bonitas ideas y que vas a recuperar el dinero muy pronto.
And all because the recruiters promise you that you're going to recuperate this money very quickly.
Pero como al no ser cierto, te llegas a endeudar de tal forma de que te sientes atrapado por eso. Y eso es lo que no te permite de protestar en contra de un maltrato de los patrones.
But when you find that what the recruiter told you was a lie, your debt is growing hugely, and that's what prevents you from protesting or from raising your voice against the abuses that your boss is doing to you.
Thank you. I yield back.
Thank you, Mr. Foster. I want to thank the witnesses for taking time to share your experiences with this subcommittee. And it is clear that the Department of Labor failed to adequately protect your rights. When people come to this country and use a legal process to get here, they should be entitled to the protections of law. You are not. The recommendations you've provided for how the Department of Labor can better ensure guest workers' rights are insightful, and this committee will continue to press the Department of Labor to take actions that would protect the rights of workers. In many ways, I believe workers' rights are human rights. Yo creo es muy importante pelear por los derechos de los trabajadores. So I thank you very much for being here. And the first panel is dismissed. Let's go to the second panel.
Thank you.
Thank you.
It's time to hope.
As the second panel is getting into place, I'd like to begin the introductions of the second panel. We have Mr. Saket Soni is co-founder of and organizer for the New Orleans Workers Center for Racial Justice and a member of the Advancement Project, the Workers Justice Center for Racial Equality, and the New Orleans Worker Justice Coalition, which is an independent community-based organization advocating for and organizing workers in post-Katrina New Orleans. Mr. Soni also works to bring together immigrant Latinos and displaced New Orleanians. He's co-author of a book called And Injustice for All, a comprehensive documentation of the conditions for workers in post-Katrina New Orleans. Ms. Mary Bauer is the director of the Southern Poverty Law Center's Immigrant Justice Project, now located in Atlanta, Georgia. The Immigrant Justice Project represents guest workers and other low-wage immigrant workers in high-impact cases in 9 states in the South. Ms. Bauer is the author of Close to Slavery, Guest Worker Programs in the United States, published in 2007, and Under Siege, Life for Low-Income Latinos in the South, published in 2009. Prior to joining the Southern Poverty Law Center, she was the legal director of the Virginia Justice Center for Farm and Immigrant Workers and legal director of the Virginia ACLU. Catherine Ruckelshaus is legal co-director at the National Employment Law Project in New York City. Her primary areas of expertise on behalf of low-wage workers are the labor and employment rights of contingent and immigrant workers. Ms. Ruckelshaus co-founded the National Wage and Hour Clearinghouse, dedicated to advancing labor standards for all workers. Among recent cases, Ms. Ruckelshaus was lead counsel in the class action Ensumana versus Christedis, a Fair Labor Standards Act case brought on behalf of nearly 1,000 West African immigrant grocery delivery workers against the contracting services who hired them and the stores who employed them. That case netted over $6 million in unpaid workers for the wages for the workers. Patrick A. McLaughlin is PhD research fellow at the Mercatus Center at George Washington University, which he joined in the summer of 2008. He was previously a graduate research fellow at the Property and Environmental Research Center. Dr. McLaughlin's research interests include environmental and homeland security regulations. Some of his current research is particularly focused on the consequences of regulatory actions on small business, foreign direct investment, and trade flows. He's been published in World Economy and Regulation magazine. I want to welcome this distinguished panel of witnesses. It is the policy of the Committee on Oversight and Government Reform to swear in all witnesses before they testify. I would ask that you now rise and raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Let the record reflect that each of the witnesses answered in the affirmative. Thank you for being here, Mr. Soni. Let's start with your testimony. I would again remind the witnesses that your entire testimony will be included in the record of this hearing. I ask that you keep your testimony to try to keep it around 5 minutes or under 5 minutes. That would be appreciated. Please proceed, Mr. Soni.
Chairman Kucinich, as members of the subcommittee, I want to thank you for the opportunity. Katrina, of the post-Katrina reconstruction. I also want to thank you for this opportunity to talk about how this exploitation has been directly enabled by the inadequate response and indeed the abject absence of the Department of Labor Wage and Hour Division. My name is Saket Soni. I'm the Executive Director of the New Orleans Workers Center for Racial Justice. And in 2007, we founded the Alliance of Guest Workers for Dignity, the only organization in the United States that is membership-driven, that brings guest workers together on H-2B visas across many industries, sectors, and countries. Our members come from around the globe, including the Dominican Republic, Mexico, Peru, El Salvador, Brazil, Bolivia, and India. In the last 3 years, we have had hundreds of consultations, conversations, and interviews with guest workers. Facing severe labor exploitation in a vacuum of federal worker protections, our members have organized and exposed exploitation within this program. Since Hurricane Katrina, hundreds of our members have also brought 4 major lawsuits against employers whose abuse is exemplary of the realities of this guest worker program. Earlier on the last panel, you heard the testimonies of 3 of our members. I would like to start by sharing with you some of the stories of our members that illustrate the severe exploitation that they face and that expose the pattern of abuse that is pervasive in the guest worker program. You all know, of course, the story of Decatur Hotels. Decatur imported workers from Peru, Bolivia, and the Dominican Republic to come to the United States. These workers arrived heavily in debt and faced exploitative conditions. They also faced threats for raising their voice. Patrick Quinn, the luxury hotelier who brought these workers from these countries, did it at a time when hundreds of thousands of American workers, African-American workers, were displaced from the region. And when hundreds of unemployed African-American survivors of Hurricane Katrina were living in his hotels. At this time, the Department of Labor certified him to bring guest workers, agreeing with him that he couldn't find a single U.S. worker willing or able to take these jobs. If Mr. Quinn had wanted to hire U.S. workers, all he would have had to do would be to go to one of the floors of any one of his hotels and knock on the door. Instead, he brought workers to do $14 and $12 an hour jobs at just above $6 or $7 an hour from Latin America on H-2B visas. Meanwhile, guest workers in Mississippi and Texas who were brought from India escaped a situation of severe labor exploitation, and along with other organizations brought legal suit in Louisiana against Signal International and an international recruitment chain that plunged these workers into debt, brought them here, and exposed them to exploitative conditions. In Tennessee, while an economic crisis engulfed families in the South, a company called Cumberland Environmental Resource defrauded both the U.S. government and guest workers to bring them here. They said there would be work in Tennessee. The workers were brought, and for 3 months, there was no work. The workers were then leased across the South in several states, astonishingly, even at military bases. Meanwhile, Cumberland represented to the U.S. government that local workers had applied for the jobs, but when they had been offered the jobs, had turned them down. When we interviewed the local workers who had applied for these jobs, every one of the interviewees said that they were in a state of economic desperation when they applied, and they would have gladly taken those jobs. Every one of our interviewees said that if the jobs had been offered to them, they would have taken them. The reality is, though, that these U.S. workers could not have taken the jobs at the wage rate offered and on the terms and conditions offered by the company. These stories reveal a pattern of abuse, and they illuminate a structure of exploitation. And I would like to unpack a little bit what hundreds of our members have reported as the salient features of exploitation within the guest worker program.
The gentleman's time has expired.
Okay.
Your complete testimony will be included in the record of this hearing, and we thank you for being here and for making this presentation. But I will assure you that everything that you present to this committee is going to be analyzed and followed up on. Ms. Bauer.
Thank you.
Thank you.
Thank you, Mr. Chairman and members of this committee, for inviting me to speak about DOL's role in protecting H-2B guest workers. You have heard substantial testimony today about the abuses endemic in this program. I have personally represented and interviewed thousands of guest workers over the course of my career. I can certainly confirm that our experiences representing H-2B workers reveal that the program is deeply flawed. Further, it is clear that the flaws in this program are not the product of a few bad apple employers, but are the product of the very structure of the program and the utter failure of the Department of Labor to take action to protect these workers. None of the significant protections that have existed, at least on paper, for H-2A workers, for example, have been adopted relative to H-2B workers, as the Department of Labor has never promulgated substantive labor protections for H-2B workers. So there's no requirement for free housing in the H-2B context, no requirement that housing be decent, and when they are abused on the job, H-2B workers are not even eligible for federally funded legal services. Under this system, workers lack the real ability to combat exploitation. Historically, the Department of Labor has taken the position that it could not enforce the H-2B contract. Thus, in their view, if a worker was promised a prevailing wage rate of $12 an hour, but paid only the federal minimum wage, the DOL would take no action. We believed this analysis was simply wrong, but we are heartened that there has been a formal delegation from DHS to DOL to permit DOL to enforce the H-2B provisions. Nonetheless, we should acknowledge the inadequate job DOL has done historically in protecting guest workers under the statutes such as the Fair Labor Standards Act and the Migrant and Seasonal Agricultural Worker Protection Act, where it has always conceded that it did have the authority. In recent years, for example, when DOL is asked how many investigations of H-2B employers they have conducted, they simply cannot answer that question, respond they don't keep records in those ways. Our experience is that they undertake very few investigations, and when they do, they tend to be limited in scope with little relief for workers. In our written testimony, we laid out some of these examples where the Department of Labor conducted an investigation, issued a modest civil money penalty, waived that penalty in its entirety when the company promised to comply with the law. We came along several years later, filed a class action lawsuit, got that class action certified, won a summary judgment decision, and obtained an expert evaluation of the records that found that major discrepancies were apparent on the face of those records, and that workers had been cheated out of something like $20 million. All of this would have been apparent to the Department of Labor had they conducted a full investigation of that company. Unfortunately, the poor track record of protecting H-2B workers is not limited to one administration or to one party. For example, the Department of Labor has historically taken the position that the one-time travel and recruitment costs of migrant workers cannot cut into workers' wages in such a way that caused them to earn less than the minimum wage in the first week of work. This has been the position of the Department of Labor since before 1970. This is an incredibly important rule under the Fair Labor Standards Act to protect guest workers. However, during the 1990s, the DOL announced that while this was still the stated position of the administration, they were adopting a non-enforcement position, and the department would decline to enforce this critical part of the law. Worse, the Bush administration tried to actively subvert the law by attaching a preamble to midnight regulations which went into effect in January of 2009. This preamble purported to undo more than 30 years of policy and law in one fell swoop and was never subjected to notice and comment. The regs that were enacted by the Bush administration eviscerated the very few protections which did exist for H-2B workers. Those regs should simply be repealed, and the department should promulgate true substantive labor protections which would serve to protect guest workers and U.S. workers in the industries which employ H-2B workers. This deeply troubled program requires oversight by Congress. Specifically, we would ask that Congress hold additional hearings on the issue related to the administration of the guest worker programs, and we're heartened that the Secretary of Labor will be back to testify about plans for this administration. In conclusion, the abuses of these programs are too common to blame on a few bad employers. They are the foreseeable outcome of a system that treats foreign workers as commodities to be imported without providing them adequate legal safeguards. Thank you.
Thank you very much, Ms. Bauer, Ms. Ruckelshaus.
Thank you, Mr. Chairman and members of the committee. I appreciate the opportunity to speak today, and thank you for holding this hearing. My name is Kathy Ruckelshaus. I'm the legal director at the National Employment Law Project. We're a nonprofit that specializes in access to and keeping good jobs for all workers. We work closely with low-wage and immigrant workers, community-based organizations and their advocates, in addition to state labor departments, to promote good models for enforcement of labor standards. In our basic work, two trends have emerged recently which touch upon my recommendations today. First, in light of the moribund federal Department of Labor enforcement, state departments of labor and state attorneys general have stepped into the void. They've launched innovative and effective enforcement programs, including state departments from both Ohio and Illinois, and the models they have enacted, I think, are good models for us to tap into for federal reforms. Second, following the virulent last 18 months of the Bush administration's workplace immigration raids, immigrant workers and other low-wage workers have virtually stopped coming forward to complain. There's so much fear out there that the complaints simply aren't coming in. Because we have a complaint-driven system in our society, that means enforcement cannot happen because workers are not coming forward to complain. My brief remarks this morning are in more detail in the written prepared testimony, but they'll reflect these two trends. For 20 years, I have worked with communities of low-income workers in dozens of job categories to ensure that they get the basics. More and more immigrant workers are not coming forward to complain, and there's no one to complain to. The testimony we have heard this morning is just a handful of examples of a larger trend that affects not only the guest workers and their families, but other workers in the same job categories, and other employers who have to compete with these same employers who are perpetuating these subpar jobs. The problem is so deep-seated, it touches jobs you see every day. The janitors who clean this building, the housekeepers, home care, and child care workers who tend our homes and our loved ones, servers in the cafeteria in this building, housekeeping staff in hotels, construction workers who build and repair these buildings, and the landscapers I passed this morning on my way to the hearing. These jobs do not have to be bad jobs with low pay. There are growth service sector jobs that could be helping create a new middle class with good pay and benefits. We can restore the promise of economic opportunity for these workers and their families by making sure these jobs pay. The Department of Labor, the 3 GAO reports in less than 1 year make the point loud and clear. The Wage and Hour Department of the U.S. Department of Labor is not effective. A decade of declining resources has not surprisingly resulted in a decrease in enforcement by 1/3, while the number of covered businesses has increased to over 8 million. Wage and Hour Division has recently relied almost exclusively on worker complaints to conduct its enforcement. When this strategy exists in the context of immigration raids in the workplace, it comes as no surprise to us that the complaints didn't come in and enforcement didn't happen. Some other highlights from these recent GAO reports I think are worth noting. These are basic problems. The Wage and Hour Division did not consistently log in worker complaints. And some regions didn't even log in a complaint until there was a successful resolution of a complaint. There's no way to measure progress or hold the department accountable if that information is not available. Delays for workers who did manage to come forward and complain were common and sometimes lasted as long as 6 months. Some offices only had voicemail and some didn't even have voicemail. This is all detailed in the GAO reports that have come out in the last year. Another problem is that the Wage and Hour Division did not seek any liquidated damages or extra penalties, so that if it did capture a complaint and get an employer to pay, the employer just paid what it would have paid the employee had it paid her correctly in the beginning. So now, what about a DOL renaissance? If only employers were as afraid of the DOL as we are of the IRS, then we'd get some traction. Much of the reform proposals listed in my prepared testimony have been enacted by the Department of Labor in the past. They're very simple, and they can send us an important and strong message. Secretary Solis recently noted there's a new sheriff in town. Well, here's how we think she can enact that message to employers. First, don't just rely on worker complaints. Department of Labor has done this before. It has targeted problem industries with audits and investigations. Department of Labor had a salad bowl initiative that looked at agriculture. It looked at nursing homes, affirmatively auditing and investigating. And this was very effective, and it can do it again easily. It should use its joint employer powers to go up the food chain when there are multiple subcontractors, as there are in guest worker programs, and it's done it in the past in agriculture and garment cases where it holds other employers and subcontractors accountable for the abuses. It can share information on violations with state and federal partner agencies, including the Internal Revenue Service, who cares about independent contractor and off-the-books payments. It also can share with state departments of labor. Maryland, Illinois, Ohio, and New York are among some of the states that are already doing this. Any sharing of this information has to include a firewall between the ICE, the Immigration Service, and Department of Labor. We've heard this morning that...
The gentlelady's time has expired, but what I'd like to do is if you would just kind of wrap it up in a couple sentences.
Okay, sure. I have a long list, and I'm not through it, but what I'll just say is that guest workers and other immigrant workers cannot police their workforces alone. The Department of Labor is the frontline agency charged with making work pay, and together we can work to make this happen. Thank you.
I thank the gentlelady. Your entire testimony will be included in the record, and also staff is going to take note of your suggestions, and we're preparing a memo to the Department of Labor which will include not just the suggestions, but some suggestions from our staffs about how we can be more effective in protection of the rights of, of guest workers. Chair recognizes Professor McLaughlin for 5 minutes. Thank you for being here, and you may proceed.
Chairman Kucinich.
And make sure that mic is close so we can hear you.
Chairman Kucinich, Ranking Member Jordan, and distinguished members of the committee, it is a privilege to be asked to testify in this forum today regarding the H-2B guest worker program and consideration of the Department of Labor's enforcement of policies related to guest workers. My name is Patrick McLaughlin, and I'm a research fellow at the Mercatus Center at George Mason University. I've been invited to share my opinion of what economic effects we should expect if the U.S. mandated that employers must pay certain employee benefits for H-2B workers.
Professor, we all want to make sure that we hear you. Is your mic's on?
I believe it's on.
Correct? And just, speak closely to it and maybe increase the volume because everyone wants to hear your testimony.
I can speak loudly.
Thank you.
I have two main points to make on this topic. First, mandating benefits for H-2B workers, while well-intended, will have unintended consequences. Second, if the goal is to help H-2B workers avoid possible exploitation, then a free agent model that empowers H-2B workers to switch employers can accomplish this goal while avoiding those unintended consequences. Consider the possibility of mandating that employers pay some benefits for H-2B workers. Regardless of the specific nature of the mandated benefit, the effect is always that employers are forced to pay more for each worker they hire. Some or all of these costs may be shifted onto the employee in the form of lower wages. There are two possible scenarios that could result from mandating benefits for H-2B workers that I will discuss. To make these scenarios somewhat more concrete, suppose that the mandated benefit in question is inbound transport costs. That is, what would occur if employers were required to pay the cost for the employee to travel to the work site. First, consider those employees being paid more than minimum wage or the required prevailing wage. The papers I examined on mandated benefits consistently present the same message. The beneficiaries of the mandated benefits mostly end up paying for the benefits in the form of lower wages. This scenario can only occur, of course, if wages can be lowered. Minimum wage or prevailing wage requirements may prevent this. The second scenario is this. Employers are legally prevented from offering lower wages to H-2B workers. If minimum wage or prevailing wage requirements mean that wages cannot be lowered, then the results are fairly straightforward from an economic perspective. Firms will seek out workers with lower benefit costs. Wage rigidities, such as minimum wage, decrease the ability of the firm to pass along the cost of mandated benefits to employees and can lead to greater unemployment. As Larry Summers put it, quote, suppose that there is a binding minimum wage. In this case, wages cannot fall to offset employers' cost of providing a mandated benefit, so it is likely to create unemployment, end quote. In the second scenario, the effect would be that potential employees that are geographically distant would be less likely to be hired compared to potential employees that are physically closer or compared to employees who circumvent legally mandated benefits, such as illegal immigrants. This suggests two implications of mandating benefits. First, while those workers who receive the mandated benefits would be made better off, some employers may opt to hire fewer H-2B workers because they now cost more. As a group, it is not clear that H-2B workers are made better off. While those lucky enough to get jobs with benefits may be better off, there will be less jobs to go around. Second, employers may choose to replace them with native workers or illegal immigrant workers. So while one consequence of mandating benefits for H-2B workers may be to make native workers relatively more competitive, another, presumably unintended consequence would be to increase demand for illegal immigrant workers. Finally, if the goal is to extend more benefits for H-2B workers or to at least avoid exploitation, one other policy that should be explored is the free agent model. That is, allowing H-2B workers to transfer their H-2B visa from one employer to another. This would encourage employers to compete for their services. If demand for H-2B workers is greater than the available supply, which is constrained by the H-2B visa cap, a free agent model would allow employers to bid for employee services so that employees will end up in the job that is highest value to the economy and highest paying to the employee. I thank you again for inviting me here today.
We thank you very much for being here. We're going to move to questions of our second panel. I would like to start with Mr. Soni. Have you seen any improvement in the amount of staff and resources available to Department of Labor's New Orleans office and Gulf Coast region since our hearings in 2007? Make sure the mic's on and bring it close.
We have not seen any significant increase or improvement in staff capacity, and we have certainly not seen any improvement in staff outreach or staff contact with community since the last hearing, Chairman.
Ms. Bauer, given your work as guest worker on guest worker issues nationally, the testimony that you've heard today, do you think that it reflects the problems in the guest worker program nationally, or are these aberrations and just sensational stories that do not really reflect the conditions that are going?
I think there's no doubt that these are problems that are the product of the structure of this program. The cases we've been involved in, many of them are national class actions, workers working not just in the South but the Northwest, all over the country, and they report the identical kinds of problems that flow from this program.
Well, in your testimony, you attached as an exhibit an article and study by the Economic Policy Institute, which found that in 7 occupations with the most H-2B workers, unemployment was higher and had risen faster since 2008 national average, while wages were lower and had risen more slowly than the national average. Now, the Institute attributes this to the H-2B program, allowing employers to look overseas for workers who are willing to take lower wages. Do you agree with this conclusion, and what are the steps that the Department of Labor needs to take in its certification process to ensure that the H-2B program does not lower wages for U.S. workers?
I do agree with that conclusion, and I think EPI did an excellent job in showing very concrete examples where workers were being paid and getting certified at dramatically less than the prevailing wage rate. And one of the problems I think that we're looking at is that in 2005, the Department of Labor changed the methodology for determining the prevailing wage rate, and wages plummeted $2 to $3 per hour, sort of in a typical case as a result of that change in methodology. The Department of Labor needs to look at the way, and I would suggest Congress needs to provide oversight for that process, at the way the prevailing wage is being calculated. We've seen many examples where people are earning significantly less than the minimum wage, and these the jobs are getting certified just at the minimum wage when workers are being paid on a piece rate system.
Thank you. Ms. Ruckelshaus, do you believe the lack of enforcement of rights of guest workers has contributed to low wages?
I think the lack of enforcement generally has contributed to low wages. I think guest workers are a microcosm of the problem that are endemic in all of these low-wage service sector jobs where there just isn't any enforcement. So I guess the answer is yes, but it's not specific to guest worker problems.
Well, in your written testimony, you state that the abuse of guest workers is bad for the economy. At this moment in time, certainly everyone here is concerned with improving the economy. Can you explain this statement and give us a better understanding of how improving the treatment of guest workers helps all workers?
Yes, what I meant by that statement was that if we don't have a wage floor, it means that employers have to compete against other employers with subpar jobs. That hurts other workers in the same sector and even in related sectors. It's bad for the workers and their families because they can't make ends meet. The minimum wage in this country is ridiculously low, and the annual income that it generates just isn't simply enough to live on. And thirdly, it hurts our state and federal coffers because there's payroll taxes not being paid. There's all sorts of other insurance not being paid. So it's a vicious cycle. It's not bringing anybody out of poverty.
Thank you. Just a final question to Professor McLaughlin. I noted you sat here and heard the testimony of the previous panel. Do you have any opinion on the Department of Labor's failure to curb the abuses of guest workers that we've heard testimony about today? How does that sound to you? You're just sitting there in the audience, and does it make you feel one way or another about the plight of these workers?
I'm sure that everyone in the audience, including myself, felt some sympathy for the plights of the workers. However, I am not certain whether the fundamental problem here is the Department of Labor's enforcement or lack of enforcement. What I think is the fundamental problem is the inability of the H-2B worker to be able to quit one job when he's in a situation he doesn't like and go work for another employer.
Well, we appreciate you being here to testify. We really do. And I'm going to now turn to Mr. Jordan, the ranking member, for 5 minutes of question. You may proceed, Mr. Jordan.
Mr. Sonai, one of the things I just want to get clear from your testimony I thought was interesting. You talked about after Katrina, many displaced residents at the hotel, and yet the Department of Labor approved the owner of the hotel bringing in guest workers when there were lots of unemployed people. I think that was maybe your exact words, right there in the facility that the individual owned. I mean, to your knowledge, did the Department of Labor even ask the question, why don't we start employing the folks who are right here and displaced people? Was that even brought up?
Well, to my knowledge, the Department of Labor did not really play a role for 3 years post-Katrina. Mm-hmm. And from enforcing the most basic wage and hour violation laws to asking the bigger questions that you're pointing to, why is one group of workers being locked out of post-Katrina New Orleans jobs while another group of workers is brought in and exploited? That was certainly not a question that was asked by the Department of Labor. It was certainly a question asked by hundreds of workers living unemployed in the hotels, as well as a question asked by hundreds of guest workers brought to those hotels.
Let me quickly go. We've all, I think you've all testified in the first panel certainly about the failure, the chairman's words in his opening statement were utter failure of the Department of Labor. I think Ms. Ruckelshaus talked about over 10 years. So we're talking the Clinton administration, Bush administration, and the current administration, at least for 3 months. And yet some of you say you think it's a good move that the DHS is moving that portion of the program to the Department of Labor. Do you really think the Department of Labor, things are going to get better?
I'll start. I mean, I think what we need to do is smart enforcement. So assuming there's always going to be not enough resources to do enforcement, the strategies have to be smart and make an impact. So collaboration, partnering, leveraging what we have, that's what I think has to change. And it seems that there's a glimmer of hope in this administration that can start to happen.
Let me quickly to one other thing. I want to bring up the professor's point, the free agent concept. I mean, to me, that does seem like, when you talk about worker empowerment, putting aside the problems that we've been outlined here and the experience with the recruiters and the lack of enforcement from the Department of Labor, your thoughts on that concept, the free agent concept that the professor has brought up?
Well, I would say that there are 4 levels at which intervention has to be made in order to empower guest workers and make the Department of Labor relevant to the lives of guest workers. First of all, there has to be an intervention at the level of debt. Whether or not workers are a free agent, if they come to the United States indentured to a large debt, it will not help them move from one shipyard to another. Secondly, there has to be intervention at the level of workers being tied to one employer, which is what the gentleman is addressing. That, however, can easily break down in the present state that shipyards, the service industry, and other industries across the South exist. There would have to be a real compliance with that rule. The third thing I would say is that workers at the moment are very clear that their legal status is tied to their employment. During periods of unemployment, for example, what is a worker to do? He can't come forward and report labor abuse if he doesn't have the next employer to go to.
Obviously, that to be if there was the change, there have to be an education component. Involved. Ms. Bauer, you haven't spoke yet, so go ahead.
Well, we agree that having a visa be portable to another employer would be an incredible improvement in this program. And if that is coupled with a serious regulation of recruitment and travel costs, that would make an enormous difference.
You really think we can get at the recruitment issue? Because it strikes me as we can say, the individual seeking to come here can't someone can't collect a fee from them, but there's going to be that incentive, it seems like to me, for folks in their native country wanting to unfortunately exploit them and take some money.
Well, that happens. There's no doubt that happens. The question is the employer who chooses that recruiter responsible? If that happened in the United States, there's no doubt that if an employer's workers are demanding kickbacks from other employees, that the employer is going to be on the hook for that.
Let me ask one other. I got 30 seconds. And any of you can grab this and know this. Just a general, I don't know kind of thing. What kind of background check is done on the H-2B applicants? Because in the earlier panel, we heard that one, and I forget, maybe it was Mr. Lopez, worked on a military base. So what kind of background check are done for these individuals? How extensive?
It's very minimal. I mean, people have to submit. The thing that the State Department is largely concerned about is to make sure that people do not overstay visas. That's the level of inquiry. And so the question is, have you overstayed visas in the past? That's the inquiry that's going on.
Okay. Thank you.
If I may, to my colleague, it seems that the only qualification is someone's willingness to work for cheap wages, or maybe to put themselves in a position where they're not even going to get paid, which is abhorrent. The chair recognizes Mr. Foster.
When I listened to the descriptions of the problems with the wage non-payment and cheating, as well as tax fraud and minimum wage violations, this sort of stuff, I wonder if there's any merit, or if it's ever been considered, to have a third party hold the wages in escrow, or perhaps post a bond so the wages will be actually there, or maybe have a third party perform the payment so that actually there's some record of this. And are there any initiatives along those lines that would at least guarantee that? It seems to me that would have two merits, one of which would be it would prevent a deal from getting struck which relied on the employer's intention to not really pay these people properly, that would just discourage it from the start. I wonder if there are any sort of initiatives along those lines that have been contemplated. Anyone?
I do not believe such initiatives exist. I mean, we suggested in our report that employers should be required to post a substantial bond to guarantee that there would be money to pay workers. I know of no serious proposals at the national level that would make that happen.
Okay. And in regards to this discussion of the free agent model, is there a way that any of you see to prevent an abuse from having people, basically you have some determination that there's a shortage of workers in some area, in some region, and then if you really have free agents, they'll immediately jump to some other region, some other industry, and it won't be two equivalent shipyards interchanging. And so isn't that a real complication with this? That when you said, okay, I want to go to this other employer, you'd have to say, okay, now is this employer in a similarly situated labor market?
I mean, I think if you do have visa portability, you have to change some of the fundamental premises of the program, because it's not necessarily no longer this employer who needs guest workers who can't find other workers here in this country.
I mean, there really needs to be an industry assessment and a geographic assessment of industries, sectors, and geographies that need temporary workers. There would probably be a way to construct the ability of workers to move back and forth within employers, within those sectors. The thing that hundreds of members of our organization will testify to, though, is that without the ability to change from one employer to another, they have no ability to negotiate, and they have no leverage with their employers.
If I might, former Secretary of Labor Ray Marshall has suggested the creation of a kind of independent agency to determine need in just this kind of circumstance. That would not be an employer-driven agency, but that would be a U.S. agency that would evaluate whether seasonal workers were really required and where.
If I may also comment on that briefly, it seems like it's fundamentally an engineering and information problem that you're addressing. The incentives for both the employers and employees are obviously well addressed when the free agent model is adopted. Now, the complications of adopting that model, I think, have been to some degree addressed previously. How do you get the information about where free agent employees are to potential employers? But I don't think that changes the fundamental incentives.
Yeah, well, I must say I found your attraction for this free market concept, that somehow we have agents with perfect information and perfect language skills and everything else that would be necessary for that to happen, is sort of interesting. I was wondering, in terms of I was disturbed by the failure to even log in complaints that was mentioned, I guess, in Ms. Ruckles. And I was wondering if some sort of daylight or public scrutiny is relevant there. I don't know if these have to be private complaints, or would it be all right with the typical complainee if they actually just sat there and dumped it on the internet so that this was visible to everyone, that this was an unresolved complaint?
I mean, I think it's deeper than that, because there's nothing even there to post up on the internet right now, because the offices aren't collecting the most basic intake information. That's the first step, is just to get them to log in, what the complaint is and what the claim is. Then there would be a question of how much, there's proposals to put scofflaw employers up on the web so that employees can see, oh, I'm owed money, or he's already paid money for me. So I think there are privacy concerns, but those can be dealt with. The government agencies get data. Your offices have constituency data coming in all the time from calls from constituents. We're talking about really basic, simple stuff that I think shouldn't be a problem.
Do you know if the Department of Labor maintains a publicly searchable database of debarred employers or people who've abused or defrauded employees?
So the prevailing wage section of it does, but the other parts do not, because the data is not there.
Okay. Thank you. Yield back.
I want to thank the witnesses and this panel. Your testimony is something that each member of this subcommittee will take careful note of. Our staff will pore over it to come up with recommendations to the Department of Labor. I want to thank each and every member of this panel for their presence here and for their thoughtful testimony. I would like you to know that this subcommittee will retain jurisdiction over this. I have talked to the ranking member, and we're going to look for ways that we might be able to make joint recommendations to the Department of Labor. I also want to say, as the chairman of this subcommittee, the people who were involved in the offenses, who have apparently not yet been called to legal accounting, the subcommittee will continue to look at the process that has caused them to escape accountability. I'm Dennis Kucinich, Chairman of the Domestic Policy Subcommittee of Oversight and Government Reform. I'm joined by the ranking member of the committee, Representative Jordan of Ohio. And, of course, we're here with Mr. Foster from Illinois, who's been here throughout this hearing. This has been a hearing of the subcommittee on the H-2B guest worker program and improving the Department of Labor's enforcement of the rights of guest workers. This is one of a series of hearings by the subcommittee on this subject. I want to thank each and every one of the members of the panel and the previous panel for their testimony. I thank you very much for your presence here today. This subcommittee stands adjourned.